one of the properties was purchased by the husband in the name of the wife. Whether that property becomes wife's or husband's.
So the property belonged to Rangamma.
Yes.
How she acquired?
Now, one property by inheritance. She was a homemaker.
She is
had no
gifted
income. It is
that
the husband who purchased it, and therefore it cannot be said that it is her absolute property.
Benami transaction.
Yes. Property, purchase of the property in the name of wife is permissible, spouse is permissible.
Yes.
It is not hit by the provisions of the Benami transactions.
Yes.
Is it only purchased in the name of the wife or is it purchased by the wife? That requires a trial.
If it is purchased by the wife,
Hmm.
there is no necessity of section 14(1). But if it is purchased in the name of the wife, then this issue may arise, whether it is her absolute property or not.
Question is whether section 4
Yes.
overrides section 14(1).
That's
Suit for partition matter. Appealed by the plaintiff. Suit is dismissed not on merits, but on an application filed by the third respondent, defendant, under Order 7 to 11A.
Yes.
Now, there are only two properties. One of the properties was purchased by the husband in the name of the wife. Whether that property becomes wife's or husband's. That is one aspect of the matter, my lord. Secondly, other property-
Relationship.
My lord?
Tell about the relationship of the parties.
Relationship. My lord, first respondent, now of course, after filing of this appeal, she died. She is the mother of the plaintiff number 1. The plaintiff, my lord, or I will put it as appellant, is the daughter of the first respondent. Now she is deceased after filing of this appeal. The second respondent is a daughter of the first respondent. Similarly, third respondent is the son. Fourth respondent is the daughter.
All right. As on the date, in whose name the property stood? As
Madam?
on the date. As on the date of the suit, the property was standing in whose name?
The property, of course, stood in the name of the Rangamma, that is the deceased first respondent.
All right.
There is no dispute of
All right.
Question is only,
So the property belonged to Rangamma.
yes.
How she acquired?
Now, one property by inheritance.
From
The father, grandfather, like
her father.
the other one, husband purchased it in her name.
As far as one property which she had inherited from her father, the suit is not maintainable during her lifetime. Right?
Now that question may not arise
Because she is no more now. Yes,
She is no more.
correct.
And with respect to that property, at least, there
So-
should be a partition.
Correct.
And
The plaint
No.
can't be rejected in its entirety.
no, as on the date of the order passed, it is legally valid.
It's too technical now.
Now
Subsequent
situation
development.
might have changed.
Subsequent development.
Now the situation is, kindly see para 3 and para 4 of the plaint. They admit that the suit schedule property item number 1 is purchased by Rangamma. So it is under the sale date. So section 14 of Hindu Succession Act applies. It's her absolute property. Insofar as item number 2 is concerned, she got it from her mother, not the father. Her mother purchased it.
Whatever. Now she is no more.
She gifted it.
Question opens now.
But as on now the suit will be decided as on the date of the suit. No,
You're asking
there
them
is
to
no
conclude.
further development. Insofar as the first item is concerned, she has already executed a gift deed in favor. That is also mentioned in the plaint itself in favor of respondent number 4. So therefore, as against that property, suit may not survive.
No, first property means
Item number 1.
property inherited from
She purchased by her.
purchased. During pendency.
No,
No.
earlier.
earlier,
After that,
her
suit
case
is filed.
is, she was a homemaker.
She is
had no
gifted
It is
that
the husband who purchased it, and therefore it cannot be said that it is her absolute property.
The donee is also made a party.
Dhoni is also made a party. Dhoni is also.
Suit has to be tried now.
My lord, there is one decision of the apex court which says that by whatever way the property is acquired by a woman will become her absolute property.
That's understood.
Yes.
In respect of another property.
In respect of other property, now situation is changed.
Yes.
So in fact, though the order valid as on the date of that may be shown and
Correct.
he may be given an opportunity in so far as
Correct.
second property.
So when the suit is being tried for one property,
Yeah.
let there be a trial for one more, another property also.
No, it may not because that will displace the
Alright,
deed
if
executed by the mother.
If you have stated
Yes.
that the property is purchased by Rangama, then there ends the matter.
Husband.
You have stated so.
Yes.
Husband.
So many.
So even then it becomes season of property.
Yes.
It's in the nature of a gift by the
Therefore, I
husband to the
submit
wife.
to my lord whether property purchased in the name of the wife by the husband, whether it could be said it is the absolute property of the wife or the husband. On that issue, I just pass on one judgment.
See, section 4 of Benami transactions,
Benami transaction.
yes. Property, purchase of the property in the name of wife is permissible, spouse is permissible.
Yes.
It is not hit by the provisions of the Benami transactions.
Yes. Even then, my lord, the section 14.
Now, section 14 will apply in a situation where the property is given to a lady in recognition of her pre-existing right and limited right is given.
No,
This is not a case of limited right.
Exactly that point is considered by the Supreme Court in 2000, reported in 2009 to 15 SCC 756, which in fact relayed by before the trial court and
If this judgment is rendered probably after considering the evidence on record. For trial, this judgment is rendered.
this,
Now, for this reason, probably it requires trial.
but ultimately they have interpreted section 14. That's why section
Based on
14 of
Based on evidence.
no, evidence is ultimately the property is purchased in the name of the wife, whether it is absolute property or not, is the only question that is ultimately considered by the Honorable Apex Court.
Is it only purchased in the name of the wife or is it purchased by the wife? That requires a trial.
Even if it is in the name of the wife or purchased by the wife, in both the cases, if it is purchased by the wife, there is no necessity of section 14(1). But if it is purchased in the name of the wife, then this issue may arise, whether it is an absolute property or not. That has been considered in this judgment.
Which paragraph?
The question, the facts I will show para 2, my lord, and then I will come to para 9. Para 9, they have considered 14(1). The dispute arose out of the partition filed between these Nagaratnama, wife of Srinivas, Hemalata, who was the minor at the time of filing of the suit in 1992. Plaintiff was the only child of the plaintiff number 1, who was her mother and natural guardian, and she represented the plaintiff number 2. The plaintiffs and respondent number 1 and 2 before the court. This suit was filed for partition, claiming 1/3 share in the social properties and also claiming separate possession by meets and bounds and by mean profits and other incidental leaves. The first defendant in the suit is the mother-in-law of the plaintiff number 1 and defendant number 2, 3, 4 are the daughters of defendant number 1 and defendant number 5 is the son of defendant number 1. Defendant number 6 to 14 are the tenants in the properties. The plaint case is that Gangama, the father-in-law of the plaintiff, expired in 73, leaving behind his wife, three daughters and 2 sons. The genealogical is so and so. The first defendant, being a housewife, had no income to purchase the
No,
property.
that's a matter of trial. Whether she had income or not is a matter of trial.
That exactly is the question.
If I may be permitted.
One
to-
aspect. Second
Yes.
aspect, probably,
Yes,
if she is in exclusive possession of the property,
yes,
then probably we may take shelter under section 14(1).
Yes.
If rest of the family members are also in joint possession,
yes.
we don't know the real aspect. That will come out only in trial. Then probably section 14(1) has no application.
But my humble submission is once if it is acquired in the name of the wife, that is the point considered here. It will become her absolute property. If it is purchased by her, the question of applying 14(1) will not arises. If it is only purchased in her name by husband or by father, whoever,
As a Benami.
Benami strictly may not be applicable. Even then,
Benami Transaction Act came into force, prohibition came into force in 1988.
88.
But still, it
Yes.
recognizes the purchase in the name of the spouse.
Yes.
So there is a later
So
enactment.
that may not be applicable.
There is
Now
a
the
return
question is, once it is acquired, whether it will be her absolute property or it is available for partition. That is the point involved in this decision.
No, you are referring to section 14 to say that it becomes our absolute property.
Yes,
That is 1956 Act.
yes,
This Benami, section 4
Yes.
of 1988 Act recognizes the purchase of the property in the name of the spouse. So what is the implication of section 4? on section 14, that requires consideration.
Then that may be heard by your lordship because anyway trial court will not be in a position to say anything.
No, no. trial court
I will
give-
assist the court in
court
in
will
that
give-
regard. In that, because I'm not fully
In
prepared
addition to
today.
all that, my lord.
On that point. Even if it is in 88, even if it is not applicable, according to me, my humble submission, even if it is not, Benami transaction is not applicable, in this case, which I also agree, it is not applicable as per the provision section 4.
No.
Even then, the question remains is whether property which is in her name is available for partition or not between the family members and which she has gifted.
My lord,
See, section 14 would apply in a situation where the property is held by a lady as a limited owner.
No, both.
You must demonstrate.
No, that is also now settled. Now it said as a limited owner as well as the purchase. That's why it's section 14, your lordship may kindly see. That's why I read paragraph 5 of the facts. In the facts, the contention taken is house has, the wife has no income of her own and property is purchased in her name. That is the contention taken in this facts of this case. And then section 14 is referred and the law is laid down. So therefore, that may, of course, if not today, it may be heard on some other day also.
Husband is no more.
Husband and no.
the husband is no more, now wife is also.
It's also-
So implication of section 4 is the property purchased in the name of the wife by way of a Benami transaction. Though the property stands in the name of wife, actually it's the property of the husband. So the husband has died, so the succession has opened. That is the case.
That is his case.
Now,
That's where insofar, that's why I said, insofar two properties are concerned, one property is, though it is also taken by her from her mother, still it is available because she has not settled that property in favor of anybody.
there is no.
Insofar as item number 1 is concerned, it is settled. So only section 14 is involved, it may be heard and disposed.
The question is whether section 4
Yes,
overrides section 14(1).
that's what
Or
I
section
am
4
not,
gives us-
I am not ready on that point today, therefore one date may be fixed. I will try to pursue your lordship.
It's this matter after 2 weeks.
Okay.